S14A1652, Matthew Chan versus Linda Ellis. Oscar Michelen, Eugene Volek for appellant. Elizabeth McBride, Timothy McCormick for appellee.
May proceed when ready.
Thank you, Mr. Chief Justice. My name is Oscar Michelen, and together with my amicus counsel, Eugene Volek, we argue on behalf of the appellant, Matthew Chan. I will be addressing the state court issues raised in our brief, at least a few of the state court issues raised in our brief. Then I will have Mr. Volek address the constitutional issues, and I'll reserve whatever time remaining there might be for rebuttal. The court below extended the reach of Georgia's anti-stalking statute, 16590A1, in a manner in which was overbroad and not covered by the intent of the statute. The statute's purpose is relatively clear and has been made clear in decisions by this court, including in State versus Burke by Justice Melton, that it requires a pattern of intimidating behavior, but intimidating behavior addressed to a very particular intent, and that is the intent on the part of the person who ends up receiving the order of protection to make the target fear physical harm. It is not against the statute to intimidate someone for any other purpose, including to try to get them to perhaps change the method of their copyright enforcement scheme, which is what we have in this particular case, as long as you are not intending to do so by inflicting physical, fear of physical harm on the recipient. So in this particular case, the appellant operates a website. It's a very popular website. It's been cited, as shows in our briefs, in the Washington Post, among many others, discussing the phenomenon of this day and age known as copyright trolling. That is the use of copyright-controlled content to try to extract damages from recipients who are alleged infringers of that copyright-controlled content. One of the many topics on that forum, which had over 19,000 posts and receives 10 to 12,000 unique visitors a month, was discussion of the poet Linda Ellis and her poem, The Dash, which actually Chief Justice Thompson referenced this morning in swearing in our young attorneys. The main argument in the forum discussion was the sense of hypocrisy that the poem talks about living your life properly, and here she and her team are sending out letters demanding $10,000, $7,500, etc., for a simple use of a poem, let's say on a bereaving parent's website, or maybe at a funeral. And it garnered a lot of discussion. At some point, a claim letter went out for a claim of $100,000 for the use of the poem, I believe, in a book. That garnered even more discussion. The court below held that 5 posts by the appellant was sufficient to constitute the course of conduct of intimidating behavior to inflict fear of physical harm on the appellee without the appellee ever receiving any letter from the appellant or being directly contacted by the appellant. What I'd like to do very briefly is use the Alamo to show what those posts were, because what the court below did was not take them in context. We had snippets and small pieces of the posts that were read into the record that the appellant, the pro se appellant, was cross-examined by appellee's counsel. But looking at the posts shows that it's relatively clear that there was no intent to inflict physical harm. So one of the first ones, and this one is trial page 22, exhibit 3, referenced many times in the record, is "you're going to be dead right." Now we know that's a colloquial phrase. That came up, a meme, like a cartoon, of Miss Ellis, certainly not flattering, was posted on the website. There was some discussion, and the appellant said, there it is, I'm guessing April, one of the users alone, will be able to generate several crazy memes, poor Linda, et cetera, et cetera. Linda wanted to be right, well, she is dead right. So in the transcript, it appears that he said to her, "You're dead right," as if she received that message with the intent that now you're going to be dead. The next post I'd like to discuss briefly is on page 23 and 24 of the record. And this is the way it was introduced. The appellant did not underline anything. This is how the appellee introduced the post. And you could tell just from the underline how carefully chosen the one troubling sentence is. So maybe she will understand potential consequences to her personally. Now, certainly in the abstract, that does not sound great. But when you look at both the paragraph before and the paragraph after, what the appellant is talking about, and is frankly talking about in all the rests of the posts, is something that is now, again, kind of common, an internet phenomenon that we call doxing. We refer it in our supplemental brief to the second amicus brief filed in this case. And that is that you expose public information about the person. And that is all appellant threatened to do in that post and in all the other posts following. And the last post I'd just like to refer to the court is one called Ready, Aim, Fire that got a lot of talk about in the record. And again, on its face, it was referred to as a firing squad. If you look at the post, this is a meme not created by the appellant. And one of the main problems with this case is the appellant was held responsible for posts that he did not make himself, and which the court held was a violation of the order, even though he didn't do it. But you look and you see that the folks pictured, and the appellee here circled herself, they're the ones with the guns. The idea is they're going to be taking fire at people with their copyright, and we're going to expose them by pulling their pants down. Now, they make constant reference to this as a sexually explicit, misogynistic, etc. It's just an overstatement. It's an incorrect description of what this means. No one can look at this, I think, objectively and say that we're going to put you in a firing squad and we're going to harm you. So the main error substantively on the state law side was the lack of consideration of the intent. On the procedural side, there were two very significant errors. Yes, Justice.
What about the order is it that you're expressly challenging? Is it the paragraph that says that your client is supposed to remove all posts, or is it the language that says stay away from, I forget the other person's name, but stay away? Are you contesting both aspects of it or just the posts?
We're contesting all aspects of it in the sense that there was not enough evidence to support the basic grant of the order in the first instance, which would include a stay away. The client never went, has no interest in going near Ms. Ellis.
Is there such a thing as, to the extent that some of this language could be perceived to be threatening physically, is it proper to preempt that by ordering your client to stay away?
No, if the court found, as the court did here, we argued it so erroneously, but certainly if the court found that the appellant's conduct reasonably placed the appellee in fear of physical harm, then they had the right to do the stay-away order. Certainly, we argue, and my amicus counsel, I'll cede the next portion of the argument to, will argue that it was way overbroad. I mean, it took down 1,900 posts discussing copyright law, discussing overuse of the copyright law, discussing the poem in general, and it took them all down with a broad brush and said that the appellant may never speak about her again, otherwise that would constitute contact. Before I just turn over to the amicus counsel, I just want to point out also the court allowed into evidence the entry of an affidavit by Timothy McCormick, who's here now as amicus counsel for the appellee, which contained numerous posts, opinions, and facts about the appellant. The pro se appellant did raise an objection. The court held that it went to the weight and to the admissibility, but nevertheless, it did go into evidence. He was questioned about it extensively, and we argue that was error also.
I'll ask you one quick question. The statute says that intimidation is putting a person in reasonable fear for such person's safety. It used to say put someone in reasonable fear of death or bodily harm. And the General Assembly at some point after the statute was originally enacted changed that to safety. Do you think safety still means only physical harm, or is it broader?
I think it can only mean physical harm because that's just an inherent language of stalking statutes in general. And here in particular, there's been no case law that I've seen where it's been used to mean anything but instilling fear of physical harm in the person. It would be extraordinarily overbroad, and who would determine what safety means if it meant anything other than physical danger to yourself or a family member? There being no other questions, I'll now turn to my amicus counsel. Thank you very much.